Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Lastly, under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on a government? You may begin when ready.
Famed jurist William Blackstone once said, "To bereave a man of life or by violence to confiscate his estate without accusation or trial would be so gross and notorious an act of despotism as must at once convey the alarm of tyranny throughout the whole kingdom."
Blackstone was referring to due process, but more specifically to habeas corpus. Derived from Latin with the meaning of "may you have the body," habeas corpus is the simplest form of democracy because it protects the fundamental right of people to be lawfully brought before a judge or court to be tried. Without it, despotism would take the reins of the judicial system and soon after take the other branches of government with it.
Habeas corpus is a fundamental right that protects people from unlawful and indefinite imprisonment. Habeas corpus refers to the English common law practice of writ of habeas corpus, where custodian of an individual in custody to produce the individual before the court is required in a legal system.
We can see the evolution of habeas corpus with the Magna Carta, the earliest example of English law, which states that no free man shall be taken or imprisoned, but by lawful judgment of his peers or by the law of the land. This means that any prisoner who has been detained cannot be held without trial in front of a jury.
In the Constitution, amendments having to do with due process, such as the Fourth and Fifth Amendments, were influenced by the core idea that habeas corpus mandates representation for detainees.
Habeas corpus is absolutely essential to limiting arbitrary government power. The idea of a limited government is that the government should operate a minimalist intervention policy where it concerns a person's individual liberties. There is no better way to do this than by having habeas corpus because it upholds the rule of law.
By assuring that all those who are under arrest are seen in front of a judge or a jury of their peers, governments assure that the most basic of judicial rights are not defunct. And when this basic right is upheld, it stands as a building block for more forms of due process to take place, such as more procedural rights.
The actual idea and process of habeas corpus has not really changed in the 250 years since the revolution. We believe that our founding fathers and our contemporary politicians hold a similar belief that habeas corpus is absolutely essential to maintaining our democracy.
The only occurrences when habeas corpus can be suspended are in times of war and/or rebellion, as expressed in Article 1, Section 9, Clause 2. An example to show the severity of the act being suspended was the use of it in the Civil War, when habeas corpus was suspended to silence dissenters and rebels. However, what has changed instead is the argument of to whom habeas corpus applies.
After the September 11th attacks, the United States was involved in the war on terror and was faced with many potential enemies from various nations in the world. Many of these enemies were imprisoned on a naval base owned by the United States in Guantanamo Bay. A major point of contention that has changed throughout the years is whether or not these prisoners have the right to habeas corpus.
In Bobanine versus Bush, the court ruled that under Article 1, Section 9, Clause 2, prisoners, regardless of being aliens or not, are entitled to be brought before a court. This case was decided 5-4, showing that the debate around habeas corpus is relevant with this contemporary issue of national security.
The debate surrounding whether or not enemy combatants deserve habeas corpus has been hotly contested because of the burden placed upon the law enforcement agencies of the United States and the relatively recent problem of terrorism.
It would be much easier for the United States to imprison and question people who have not been able to go through the long-winded legal system. However, we firmly believe that this burden does not matter. If certain assets of the United States represent a significant threat to the national security of the people, then the people should know about it.
The United States government is afraid that by using habeas corpus on every single detained prisoner, it would deny or even delay them valuable information or the methods of obtaining that information from them, as was recently seen in 2011 when a Senate Intelligence Committee determined that the CIA had unlawfully tortured prisoners and denied them habeas corpus at Guantanamo Bay.
However, this sets a dangerous precedent because it allows for arbitrary application of habeas corpus to other prisoners of the United States. If we seriously thought we were under threat or even at war, then the suspension clause would take place in the United States.
However, during peacetime, habeas corpus must be continuously applied, or else it would give lawmakers an excuse to not have it applied to the citizens of the United States as well. Cases where the US thinks it's burdened with the wartime aliens will come back to haunt us because of our disregard for the simplest way to protect democracy. Thank you, and we are now open for questions.
Okay, thank you very much, gentlemen. I'd like to go back to something you hit on in your prepared remarks, and that was Lincoln's suspension of habeas corpus. I don't have the exact quote, but you said something about this is an example of a severe use of the suspension clause. I wonder if you guys could unpack that a little bit. Like, what were Lincoln's considerations, and maybe you've already expressed your opinion if you think it was a severe use, but I'd be interested in hearing the panel's opinion on Lincoln's actions?
So in 1861, when Lincoln suspended habeas corpus, it was under fear that more and more states after South Carolina seceded would begin to secede. For example, a significant fear was that the state of Maryland would have seceded as well. And this is one of the cases where he had used in ex parte merriment. However, it was later determined after in 1863 that what Lincoln had done itself was unconstitutional, which is why in 1863 Congress took the reins and they said, we agree what you have done, but you never had the power to do it, which is why Congress suspended the power of habeas corpus in 63.
I would like to agree with what my colleagues said. For example, Justice Taney cited in ex parte merriment, he believes that this is actually a power that only Congress and the legislative body, which is a representative body of the people, only has this power to suspend habeas corpus, not the executive. He traces this back to English common law, and he actually cites William Blackstone, who we cite in our speech as well.
Like my second colleague suggested, I believe that the founders would not want the power to suspend habeas corpus to be at the hands of the executive with the president. The colonists, when they were creating the Constitution and when they fought for their independence, they were subject to the reduction of their liberties by King George, where he violated the Petition of Right, which stated that there could be no unlawful imprisonment. So when writing the Constitution, they used Articles 1 through 3 to separate the powers so that the executive could not suspend the habeas corpus, and it would be in the hands of Congress, an elected body.
Thank you.
All right, I'm going to follow up just a bit on one comment you made in your essay around due process requirements in the 4th and 5th Amendment, and you could probably add in the 14th as well. Maybe just elaborate, you said they related, maybe just elaborate a bit on how those due process requirements fit with the concept and in fact with the writ of habeas corpus.
So when concerning due process, we believe that habeas corpus is one of the 3 or 4 pillars that holds it up, along with in the 5th Amendment, the right to a grand jury, to be seen by a grand jury of your peers. So the reason why habeas corpus is so important to the concept of due process goes back to the Magna Carta, when nobles had taken away King John's power to throw anyone in prison whom he wished. The reason that habeas corpus is so important is because it restricts executive and arbitrary executive power. So when talking about due process and specifically procedural due process, it's important to see that just by having every prisoner having the right to be seen in front of a judge, to be heard in front of a jury of their peers, and to know of what they're accused of, it would by itself take away any executive power that due process protects against.
Just to build off my colleague, in the case of Miranda v. Arizona, it stated that the people have the right to hear their constitutional rights before they are being arrested. It is clearly shown that because of that court case, we are allowed and ensured that these rights are protected and secured and known to us.
Like my colleague said, the Magna Carta, states that the law should be both publicly promulgated, and also that no citizen should be, they should have equal liberties below the law. And we believe that because the Magna Carta stated that the founders put that into the Constitution with due process, and Article 1, Section 9, Clause 2 saying that habeas corpus must be given.
Thank you very much.
All right, so you referenced the notion of citizens there. Let's take it to the contemporary, our lives. Is there a habeas corpus analysis to be done in the contemporary immigration, asylum-seeking domain that we're seeing along our southern border?
Yes, there 100% is an analysis to be done, and while it is a controversial topic, we will take the side of what Boumediene decided in after 2006, and the reason for this being is that Boumediene decided in Guantanamo Bay that they used that argument of the Supreme Court in 1905 of insular cases, combined with the fact that Guantanamo was a de facto sovereignty territory of the United States, and so they decided that those imprisoned, if it's a de facto sovereignty place, then those prisoners deserve habeas corpus, and they deserve to be not held without being being shown what they're accused for. And so if that can be done in Guantanamo Bay, which is which is de facto seen as sovereignty, then it should be done along our southern border as well.
Just to add to what my colleague said, if you look at the 14th Amendment, it says that all persons, not all citizens, are entitled to due process rights. So this means that even illegal immigrants who are passing through or who are crossing the border, they actually have due process rights as seen in the 14th Amendment.
Furthermore, in Rasul versus Bush, it states that citizenship status does not matter in the case of habeas corpus. And it was ruled that foreign nationals had that right to petition against the federal courts for that habeas corpus. So I believe that if we're talking about the case of immigration along the southern border, they deserve that habeas corpus right.
Branching off my last colleague, Article 1, Section 9, Clause 2 deems that habeas corpus could be suspended in cases of invasion if Congress deems that the public safety is at hand. And like you suggested in your question, illegal immigration could be seen as invasion. However, it is not a danger to the public safety, and therefore the writ of habeas corpus should not be suspended.
Thank you.
So this issue of public safety is obviously one that underpins this entire discussion. And if we think about the folks down in Guantanamo Bay, there was some stat that was, I don't know who put it out, but the vast majority of them weren't enemy combatants or however they figure that out. But I've also seen sort of maybe right-wing commentators say things like, if I were to give you a bowl of Skittles and I told you that 5% of the Skittles were going to poison you and kill you, would you have one? Do you think that that's a solid argument against extending habeas corpus to enemy combatants?
No, we do not believe it would be a solid argument concerning enemy combatants. And because the reason for this being is that the only time we've seen habeas corpus suspended in our history has been in times of not only stress but increased rebellion. So, for example, ex parte queer in 1940 concerning a German spies who had invaded the United States. It was not quickly, but it was overturned by Boumediene because it was decided the decision made by FDR, it did not do the correct thing in that case.
There have been four.
Yeah, please finish out your thought.
Okay, sorry. Under Article 1, Section 9, Clause 2, there have been 4 instances in our 250-year history where it has been suspended. One time throughout the entire country during the Civil War, another time in 11 South Carolina counties during when they were overrun by the KKK, another time in a 1905 insurrection in the Philippines, and finally in Hawaii after the bombing of Pearl Harbor. You can see how scarce these instances of habeas corpus has been suspended. It is clear that our Congress does not want to take away this essential right to face a federal court, to protect our rights, to stand for that.
Great.
All right, good job.
Thank you. Great job, fellas.
Nicely done.
I'm looking over my notes that I was jotting down during your presentation in the Q&A. I certainly was impressed with sort of the breadth of evidence leverage. In particular, you guys quoting the Constitution chapter and verse, like just off the top of your head, but doing it meaningfully and not just Article 1, Section 9, but like saying what it represents and how it's relevant to the question or to the argument. I think is indicative of deep understanding of the issues at hand. I was particularly impressed with the nuanced understanding of the 14th Amendment. All persons, it's not just citizens. So well done there. Going forward, if you guys are going to go into law or something, or even just in college, you get the right papers, argumented the papers. Good to keep in mind the best arguments against your position. And give them a good faith effort and then annihilate them. And it'll make your argument even stronger. But otherwise, I think you answered all the points of the question clearly. And like I said, great breadth of evidence and deep understanding of these complicated issues at hand. So I congratulate you. Well done.
Yeah, I'll add my congratulations. Nicely done. It was enjoyable to listen to your essay and then to interact with you on the questions. You complement one another. You're able to add onto your colleague or teammates' arguments, and you had, as Mr. Murphy just pointed out, you're able to pull kind of supporting evidence showing your adeptness with it, as well as your critical thinking skills and citations. And so that was impressive and enjoyable to listen to. And we certainly wish you well moving forward here. And it's always fun to listen to students of your caliber, and I know you'll do well down the road. So all the best.
And of course, I echo the praise of my colleagues. It was an enjoyable conversation. You know, the time goes by quickly when we're engaged with, you know, thoughtful young people who have ideas, and you're willing and able to support those ideas. And that you don't have opinions, you make arguments, and that is what we're all about. And I'm pleased that you did that. I really like that you're grappling with the tension that exists between public order and safety, but the retention of our rights. And you took a strong position to say, look, it's not an undue burden. It's the burden of government is to make sure that it does its job, but doesn't violate those rights. And it's tough. And it's a challenge, and it's a challenge that we face cyclically in this country. As you continue to study and learn, don't forget in your prepared response, you talked about how the evolving nature of habeas corpus was also about the who, and you got appropriately into the question of aliens and non-citizens. But also, as habeas corpus was introduced as a limit on federal power only, and then it shifted with Reconstruction to affecting people in states, and now it's pretty well established wide board across the entire country at all levels of the judicial system that no matter where you're held against by whom, you will have that writ. So again, just something to deepen your already very deep knowledge. Very impressed. I'm sure you all do very well. Thank you very much.
Thank you very much.
Thank you for your time.
Thank you.
Thank you, guys.